GR. Number 250627. December 7, 2022. Jacinto, petitioner, versus Maria, respondent. RESOLUTION. Inding, J. The antecedents. The case stemmed from the following information: 6 dated June 8, 2018, filed against the petitioner for violation of Section 5A in relation to Paragraph 2 Section 6A of RA 9262 and Section 5K of RA 8369. That on or about the 14th day of January 2018, in the city of Antipolo, Philippines, and within the jurisdiction of this honorable court, the above-named accused did, then and there, willfully, unlawfully and feloniously attack, assault and employ personal violence upon the person of her live-in partner by pushing her forcefully with swaying aims and crushing her hands repeatedly with the door of the car, thereby causing upon her physical injuries which required medical attendance for a period of less than 30 days and incapacitated her from performing her customary labor for the same period of time. Contrary to law, petitioner and respondent were in a relationship for 16 years. Respondent alleged that petitioner broke up with her on December 24, 2017 while they were celebrating Christmas in Hong Kong. When they got back to the country, petitioner would come to their house in Antipolo City just to get her things, then leave to spend the night with her lover. Respondent then asked petitioner to stop using her credit cards because the latter still owed her P3 million.00. Later, petitioner started to demand that respondent leave the house and forced the latter to sign a deed of absolute sale over the property in her favor. Respondent refused to leave and sign the document. On January 12, 2018, because of respondent's continued refusal to leave the house, petitioner became angry and violent that she threatened to break everything and burn the house down. Petitioner's threats caused respondent to suffer chest pain and difficulty in breathing that she was brought to the hospital to seek medical attention. Petitioner visited respondent in the hospital on the next day and tried to make amends. When they went home, respondent averred that petitioner forced her to take Rivotril, a drug that caused her to feel weak and groggy. On January 14, 2018, when respondent regained consciousness, she was already naked with petitioner on top her, taking photos and videos of her. She then begged petitioner to delete the photos, fearing that the latter might kill her or have her killed. Respondent followed petitioner to her car, but the latter repeatedly crushed her hand with the door of the car and pushed her hard so that she fell to the floor. She suffered fracture on her left wrist and thereafter underwent surgery and physical therapy. For her part, petitioner countered that the complaint against her was filed to seek leverage for a case for reconveyance, annulment of title, and damages that she filed against respondent before the RTC of Antipolo City. She insisted that she alone purchased and built the house in Antipolo City and that respondent merely stayed therein after their breakup to seduce and provoke her. Petitioner further narrated that after respondent was discharged from the hospital, the latter seduced petitioner to have sex with her and asked her to take pictures of them while they were naked. When petitioner asked respondent to delete the pictures, the latter became hysterical and followed petitioner towards her car. Respondent grabbed petitioner's hands to prevent her from entering the car and she fell to the ground as petitioner tried to escape. Thus, on June 8, 2018, an information for violation of Section 5A in relation to second paragraph Section 6A of RA 9262 was filed in the RTC against petitioner. Petitioner moved to quash the information on the ground that the facts charged in the information do not constitute an offense because RA 9262 does not apply to lesbian relationships. Petitioner asserts that reliance of the RTC in the case of Garcia in ruling that RA 9262 applies in the case is misplaced. According to her, the petitioner in Garcia was a husband who assailed the constitutionality of RA 9262 for being violative of the equal protection and due process clauses. Thus, the pronouncement of the court that RA 9262 also applies to lesbian relationships was a mere obiter dictum in Garcia, as it was not upon the question brought before the court on petition. Petitioner adds that to assert that RA 9262 applies to lesbian relationships is to protect one woman in a relationship and deny the other woman of the same protection. Petitioner further claims that 1. The RTC's interpretation of the phrase, any person, in Section 3 of the law is patently erroneous. 2. The enumeration after the phrase, any person, has one denominator in that they refer to the male sex, husband, former husband, or a person with whom the woman has or had dating or sexual relationship, or shares common child with. 3. Following the principle of e justum generis, the person, referred to under Section 3, cannot be a woman. And 4. The recent proposal by the Congress to amend RA 9262 to expand the scope of the law to include partners and their children, further strengthens the position that same-sex relationships are not covered under the law.
Hello guys, so for today's
Further,
vlog, ang case
respondent
po
avers
natin
that
ay
RA
tungkol sa isang empleyado na
9262 is
nag-claim mula
clear and
sa
free
kanyang
from any doubt or
employer
ambiguity.
ng benepisyo
There is no room for
matapos siyang
interpretation in the use of the
magkasakit.
phrase,
So
any
ang GR
person.
number ng case
It is
ay
without regard to gender or
217-866
sexual
na
orientation
desisyon
so
nito
long as
noong
the
June
person
20,
has or had a dating
2022.
relationship with the
So
victim.
itong ating empleyado
Respondent
ay isang
also argues that
fabrication
the pronouncement
helper
of the
sa
court
isang
in Garcia is
manufacturing
not a mere obiter
corporation
dictum because
mula
one of the issues
1995
submitted in the
hanggang
case was the
February
validity of the
2010
classification
bago
between
siya
men and women that
magretiro.
would
So
justify
nagtrabaho
the
siya doon
protection
ng
given by
15
RA
years.
9262.
Siya yung
It
tumutulong
was
sa
meant to
kanilang
provide
welder
protection
para
to women
mag-cut
and
ng
children
mga
as
steel
offended parties and not
materials.
as
Pero
perpetrators.
2 taon bago siya
Respondent
magretiro,
insists that
nakaramdam
petitioner
siya
failed
ng
to
mga
establish
back
that she
pains,
is entitled
pananakit
to
ng
the
likod
relief
at
demanded, more
walang
particularly,
hintong
that she
pag-ubo.
has a clear and unmistakable
Lumala
right
yung
to be
kanyang
protected.
simptomas hanggang sa
In her
hindi na
reply,
niya kayang
petitioner
magtrabaho,
reiterates that
kaya
the issue in Garcia
nag-retire
is a
na siya
mere
sa
obiter
trabaho
dictum as
noong
the case
February
therein did
2010.
not, in any
Ilang
way,
araw lang
involve
matapos siyang
lesbian
mag-retire,
relationships,
isinugod
and
siya
that
sa
RA
ospital dahil sa
9262
pananakit
does
ng
not yet
kanyang
cover
likod,
homosexual
pag-ubo,
relationships.
masakit
The
na
court's
pag-ihi,
ruling, RA
at lagnat.
9262 applies to
Nung siya ay
lesbian
na-ospital, may mga iniinom na rin
relationships.
siyang
At
gamot
any
for
rate, the court
pulmonary
deems it
TB.
proper to discuss the
And
issue raised
na-diagnose
in the
rin siya na
petition if
meron siyang
only to reiterate
hepatitis
the
A.
earlier pronouncement in
Pagkalipas
Garcia
ng
that
ilang buwan
RA
ay naisugod na naman siya
9262
sa
applies to
ospital dahil
lesbian
sa sobrang
relationships.
pananakit ng kanyang
The
dibdib
information
at
filed in the
likod at
RTC against the
nahihirapan
petitioner
siyang
is
huminga.
anchored on Section 5
And
of
ng
RA
July 2010,
9262,
namatay nga
viz.
siya sa ospital.
Section 5,
Nakalagay
Acts
sa
of
kanyang
Violence
death
Against Women and Their
certificate
Children.
na ang cause
The
of
crime
death
of
ay
violence against women and
cardiopulmonary
their children is
arrest
committed through
secondary
any of
to
the following
prostate
acts:
cancer. Ngayon yung
causing
asawa ng
physical harm to
empleyado
the
ay
woman or her
nag-file ng
child,
claim
XXX.
for employees
On the other
compensation
hand,
benefits
Section
na
3 of
dininay naman
thereof
ng
defines
SSS
violence
dahil ayon
against
nga sa
women and their
SSS,
children as
yung
follows.
cause of death o yung dahilan
Section
ng
3,
pagkamatay ng
definition of
empleyado
terms. As
ay
used in this act,
non-occupational
of
disease o
violence
walang
against women and
kinalaman
their
sa
children
kanyang
refers
trabaho.
to any act or
Ibig
series
sabihin
of
nito,
acts
dahil ito
committed by
isang
any person against
non-occupational
a woman
disease,
who is his
kailangang
wife,
patunayan ng asawa ng
former wife,
empleyado
or against
na
a
ang
woman with
trabaho
whom
nito
the
bilang
person
isang
has or had a
fabrication
sexual or dating
helper
relationship,
ang
or with whom he has a
nagpadagdag
common
ng
child,
risk
or
o
against her
nagpataas
child
ng
whether
risk para
legitimate
siya
or
ay magkaroon ng
illegitimate,
prostate
within or without
cancer.
the family abode,
Yung
which
bilang
result in or is
empleyado,
likely
para
to result in
maka-claim
physical,
ng
sexual,
benepisyo
psychological harm or
mula sa
suffering, or
Presidential
economic
Decree
abuse
number
including threats of such acts,
626,
battery,
para
assault,
mabayaran
coercion, harassment or
yung
arbitrary
empleyado kapag
deprivation
siya ay
of liberty.
nagkasakit o
Petitioner's main
nagkaroon
contention
ng
is that the facts
nagresulta
charged
sa
in the
kamatayan
information
yung
filed
kanyang
against her in the
pagkakasakit,
RTC do not
ito ay
constitute an offense
nakalista
because RA
bilang
9262 does
isang
not apply to
occupational
lesbian
disease
relationships.
under Annex
However,
A
this
ng
issue was already
implementing
settled in the case
rules
of Garcia
ng
in this
PD
wise. There is
626.
likewise no
So
merit
ano
to the
mangyayari kung
contention that
hindi
RA
ito isa sa mga
9262 singles
nakalistang
out the husband or
occupational
father as the
disease?
culprit.
Well, kung
As
yung sakit
defined
na yon
above,
ay
VAWC may
considered
likewise be
non-occupational
committed
disease
against
o
a woman
hindi
with whom the
nakalista
person
bilang
has or had a
occupational
sexual or
disease,
dating relationship.
etong si
Clearly,
empleyado ang
the use
magbibigay
of the
ng
gender-neutral
pruweba
word,
ngayon para
person, who
maipakita
has or
niya
had a
na
sexual or
yung
dating
pagkakaroon
relationship
niya
with the
ng
woman
sakit
encompasses
ay
even
mas
lesbian
pinalala
relationships.
o mas pinataas pa
Moreover, while
ng
the law
kanyang
provides that the
working
offender be related or
conditions. O
connected
ano
to the
itong mga
victim by
working
marriage,
conditions
former
na to?
marriage, or a
Halimbawa,
sexual or
yung kanyang
dating
trabaho ba ay
relationship, it
nire-require
does
siyang
not preclude the
magbuhat ng
application of
mabibigat
the
na
principle
bagay
of conspiracy
na
under the
i-expose ba
revised
siya
Penal
sa
Code
chemicals?
RPC.
May proper
Thus, in the
ventilation
case
ba
of
sa kanyang
Gotan B,
area?
spouses
At
Tan,
ayun nga,
the
sa
parents-in-law
napakaraming
of Sharika
research,
Mariel,
maaaring magkaroon
Gotan,
ng
the
prostate
victim,
cancer
were held
ang
to be
isang
proper
trabahador
respondents in
kapag
the
siya
case filed
ay
by the latter upon the
nagkakaroon ng
allegation that they and their son
exposure sa
Gotan's husband
tinatawag
had
na
community of design and
chromium.
purpose in tormenting her by
Ngayon,
giving
yung
her
kanyang
insufficient
trabaho bilang
financial
isang
support,
welder
harassing and
assistant
pressuring her to be
sa isang
ejected from the family
manufacturing
home, and in repeatedly
corporation
abusing
na
her verbally,
nag-handle ng
emotionally,
stainless
mentally, and
steel,
physically. Contrary
na-expose
to
siya sa
petitioner's submission that the
chromium in
foregoing
varying
disquisition in
degrees.
Garcia was a mere
So
obiter
hindi
dictum,
nga
the
malayo
court
yung
notes that one of
posibilidad
the
na
issues
mas
raised in Garcia
tumaas
is the
yung
supposed
risk na
discriminatory and
magkaroon
unjust
siya ng
provisions of RA
prostate cancer dahil sa
9262
kanyang
which are likewise
exposure
violative of
sa
the Equal
chromium.
Protection Clause.
So ang sabi po ng
The
korte,
foregoing discussion
dapat
of the court as to
mabigyan
the
ng
applicability of
benepisyo
the law to lesbian
ang
relationships is
empleyado
clearly a
sa
resolution
ilalim
of the
ng batas
particular
na
issue
ito,
raised in Garcia and not a
Employees
mere obiter
Compensation
dictum or an
Law or
opinion of the court.
PD 626.
The statement of the
Dagdag
court
pa ng
that
Korte
T here
Suprema
is
dahil ang
likewise
PD
no merit to the
626
contention that RA
o ang Employees
9262 singles out
Compensation
the
Law ay
husband or
isang
father as the
social
culprit,
legislation
further amplifies
na
that the
para
issue
sa
of whether RA
empleyado. Dapat
9262
itong
only applies to male
i-interpret
perpetrators was
na
indeed raised in the said
naaayon
case.
o nagiging
Applying the
pabor
case of
sa
Garcia, the
manggagawa.
motion to quash information
So
filed
para
by
po
the
sa mga
petitioner on the ground
manggagawa
that the
pa
facts
dyan, sa
charged
mga
therein do not
empleyado
constitute
na
an offense
gustong
utterly
mag-claim ng
lacks basis.
benepisyo under
Wherefore,
SSS
the
dahil
petition is
pinaniniwalaan
denied.
ninyong ang
So
inyong
ordered.
sakit o